And on the line we have with us attorney at law and member of the Police Service Commission, Martin George. Good morning to you, Martin George.
Good morning,
Hi,
Mr.
good
George.
morning to you, Jessamy. Good morning, Dr. Wayne, and good morning,
sir.
Edison.
Martin George, you may have had an opportunity to peruse the judgment brought by the learned Justice Myradine Amora. What are your thoughts on the ruling itself? Is it very clear? Is it confusing? Did she leave a back door open for further discussion and litigation?
Well, the thing is, I would think that it's a mixed bag in the sense that while she was very clear that she was of the view that the election result was not affected by what transpired, I think the finding of illegality against the EBC is something that I think certainly opens the door for an appeal to be founded or based and to be moved to the Court of Appeal. So, as I said, it is a mixed bag. And if you recall, Jessamy, when we discussed this matter several months ago on your show, with Dr. Wayne and Edison, I was of the respectful view that the EBC may have made errors of procedure. You recall that's how I described it. I said it may have been errors of procedure. But the thing is, I am not sure necessarily that, at the time that I would have, gone so far as to hold it illegal, because when one looks at their constitutional remit, this judge, however, has ruled differently. She has said, she's actually held it to be illegal. So I think one way or the other, that is an issue that has to be ventilated at the Court of Appeal. So, apart from, persons pursuing their narrow partisan interests, I think there's a bigger issue here at stake as to what is the role and remit and the limits of authority of the EBC, because this is just one scenario which occurred on that particular day. But there could be other things that could happen. There could probably be other acts of God or riot or something that, the EBC may need to take a decision to say, well, okay, what do we do in such circumstances? So I think it is something that really needs to be clarified as to what is the limit of their constitutional authority and the limit of their power under the Representation of the People's Act. And so it is going to be an interesting appeal in that context.
And in terms of the language that she used, terms like they did what they did in good faith, in other words, there was no diabolical plan to give one side an advantage over the other. They looked at the circumstances on the day and they did something that they thought would benefit everyone. That's how I interpreted that statement.
Right. Well, this is the point. And you see, the thing is, that's why, as I said, my initial view has always been that it may have been procedurally incorrect. But certainly, I think there's absolutely a total absence of any malice or any,
hidden agenda.
Intent. Right, any intent for illegality or unfairness, I was particularly surprised at the language employed by the lead counsel for the petitioners who would have been representing the UNC and the former PP government, because the thing is, I'm sure that in the courts in London, he would not use such inflammatory language, but I guess he felt he had the license, so to do, coming down to Trinidad and Tobago, because the thing is, the way he described the election as a sham and, all these things, it's really an attempt to make a damning indictment against the EBC when clearly the judge found no such indictment. In other words, she herself, even though she made the finding of illegality in terms of their action in that regard, I think she was very careful to try to clothe it in language which suggested that there was no malicious intent whatsoever underlying or underpinning their decisions.
But if the word illegal was used by the judge, Mr. George, wouldn't anything that springs therefrom be also illegal?
Well, not necessarily, because what it showed, and she was careful to make the distinction that, look, notwithstanding the illegality that she said that they didn't have the power or authority to extend the time,
yes,
the voting time, I think the evidence is what, swayed the day, because she was clearly able to analyze the evidence and to show that, look, notwithstanding whatever votes would have been cast between the hours of 6 and 7 p.m., those votes could never have changed the result. So therefore, in other words, even though there was an illegality, so in other words, it becomes more now of a technical and a specious argument as to the limits of the EBC's power, but it has moved past the question of affecting the election result. You see, so that's the distinction that the judge made.
In that ruling, Mr. George, those who made the decisions, be it the commissioners, I would imagine, shouldn't there be accountability, as there's a call from Mr. Munilal, Dr. Munilal, that they should be fired? In other jurisdictions, do we have any case study where the commissioners was dismissed from their responsibilities?
Well, the thing is, I think the first thing we would need to look as comparators would be Commonwealth jurisdiction. And from what I have seen, I have not seen any circumstance necessarily where, in a scenario where there's absolutely no malicious intent, and I think the judge is clear on that, that there was no malicious intent by the EBC, that you've seen situations where persons are dismissed from their portfolios in that regard. And we must also remember that the current chairman of the EBC, remember, he was not in office at the time of this election, right? It was the former chairman, Dr. Norbert Massoum. So therefore, the question of firing, I am not sure it necessarily arises at all. And we must remember how these EBC commissioners are appointed. They are appointed by the president. So therefore, it might be, I guess, a knee-jerk reaction. And of course, it may be a good political soundbite for Dr. Munilal to say so. But I think once we sit down and we do the cold, hard logic and reasoning of the scenario, I'm not sure it's a call that necessarily would be justified.
Looking back at what statements would have been issued by the EBC itself at that time, if I remember them correctly, they would have quoted Section 71 of the Constitution, and particularly subsection 12. In the exercise of its functions, the Commission shall not be subject to the direction or control of any other person or authority, indicating that they are an independent entity. And they used that as a key argument, indicating that they did have the authority to do what they did, that they did exercise, they did have the power to exercise their judgment in the way that they had.
Right, you see, okay, but here's the conundrum, Jesse. While the independence provisions are clearly set out and they are insulated from interference by any other body or persons or organizations, and that is very clear, and I don't think anybody disputes that. What the judge held on to was, look, under the Representation of the People's Act, it clearly sets out that the polls must close at 6 p.m. So what she's saying is that you don't have that power or authority to change the law in that regard.
Even if you go to the Representation of the People Act, Section 3, where it says the Commission shall exercise general direction and supervision over the administrative conduct of elections and enforce on the part of all elections officers fairness, impartiality, and compliance. Even if you look at that, I mean, does that not give them the space to use their good judgment to ensure that they supervise the administrative conduct?
All right. So the thing is, that is one of the general provisions. And it comes down to a question of statutory interpretation, because, in other words, does a general provision or a sweep-up clause, which gives you umbrella powers, does that override a specific provision in legislation which sets hours? So you see, the thing is, I think that's where the argument is.
Okay.
In other words, can you then use, in other words, if I set specific timelines, that means I have addressed that issue specifically. I've set that in the legislation. Does your general power allow you to change that specific? Normally, in statutory interpretation, you would say that, look, if Parliament took the time to specifically address the issue of the opening and closing times, then that shows that they have focused on that as something they wish to have set and fixed. So therefore, normally, you would not say that your general power to supervise and manage elections can override that fixed provision. So I think that's the logic and the reasoning that the learned judge would have applied in terms of her analysis to say, well, look, notwithstanding that you do have the general overriding supervisory powers, you ought not to interfere or tamper with the fixed times as set out specifically in the legislation. So that's where the argument is. And as I said, it really does raise the argument in the Court of Appeal that is going to be quite interesting.
Mr. George, does independent necessarily mean unfettered? How would you interpret those two words?
No. They're not the same. If you recall, even the decision of Nizam Mohammed versus where he brought action to challenge the decision of the president to dismiss him as head of the Police Service Commission, the judgment of Justice Judith Jones, she indicated quite clearly, right? I think President George Maxwell, which was the president at the time, Justice Judith Jones, in her judgment, she indicated quite clearly that notwithstanding that even the office of the president is insulated even from legal challenge, because of the ouster clause, what she said is that, look, it must always be that your discretion and your power and your authority would be exercised correctly and within the boundaries of the legislation and the law. If it is exercised outside of that, then she says that stepping outside of the lines, so to speak, is something that can be challenged. So to bring it back to the context of your question, even independence must be circumscribed by the four corners of the law. So in other words, I cannot say, well, look, because I have independence,
I can do as I wish.
Decide, well, look, I'm going to hold the election period for 24 hours instead of the 6 a.m. to 6 p.m. as set out by the legislation. So unfettered doesn't mean that you have a license to do as you wish. It's not the same thing at all.
Folks, I need to take a break very quickly. Martin George, we're going to come back with more in this discussion. Keep it right here on Sky.
Don't touch a button. We'll be right back with more on Sky 99.5 FM.
And we're back on the Breakfast Roundtable here on Sky 99.5 FM. In the spotlight, the ruling on the election petitions brought by the United National Congress concerning the September 7, 2015 elections. And the judge trying to be as fair as possible in her discourse, Martin George.
Yes.
And also citing several bits of case law from around the Commonwealth in order to explain why she took the path that she took in her analysis and eventual judgment.
Yes. Now, the thing is, Jesse, I would think that we can't escape the fundamental factual matrix. And I think any court properly directed and guided must consider the factual matrix, because not every illegality would necessarily result in a sanction to say that, look, your entire process is flawed.
Mm-hmm.
You know, this is the nub of the issue. In other words, was it so fundamental as to have affected you or affected the result? And that's the distinction that this judge carefully made, and she made a finding of illegality, but said that, look, when one looks at it, notwithstanding the illegality, even if I were to strike out all that flowed directly from the illegality, which would have been all the votes cast after 6 p.m., then it still did not change the result. And that is a factual matrix that no one can disturb or upset. So therefore, any court seeking to say, well, look, I am going to impugn the entire electoral process will first have to cross that factual hurdle. In other words, how do I impugn the votes of all the others, the majority of voters who would have voted in a particular way for the sake of those who would have voted after 6 p.m. when their votes could not and did not make a difference to the eventual outcome.
We've got a caller on the line seeking further clarification. Good morning. You're on the Breakfast Roundtable.
Very good morning to you, Jesse.
Good morning.
And to Mr. Carr.
Morning,
and to Dr.
Senators.
Wayne.
Sir.
Good morning, Mr. George.
Hi, good morning.
Mr. George, the UNC partnership was saying that as a consequence of the illegality of the EDC, by extending the time for the election, it affected them. But had the partnership or UNC, whichever it is, just dealt solely with the fact that the EDC was illegal by extending the time, deal with that only. Do you not think they would have had a better case rather than saying it was as a consequence of the extension of the time? Thank you.
Well, the fact is that in such circumstances, you must always, in approaching the court on such matters, show how it has affected you, because it goes to the question of your locus and your right to be heard. Mm-hmm. So if you are not able to show that, then it always creates a difficulty as to why are you here in the first place. Is it that you are just seeking clarification on this issue without seeking to get some personal benefit from it by showing that, look, I have been affected and therefore I want the result to be overturned? I mean, yes, I take his argument that they could have structured their case differently, but given the fact that we're talking about politicians, I would find it very difficult to think that they would ever want to make a case just as a theoretical argument as to the illegality of the EBC without going the further step to say, well, look, as a result of that illegality, I suffered, so therefore I want to get some benefit by having the results overturned. But of course, as I say, these issues must be ventilated in terms of the overall role, power, authority, and remit of the EBC. I think it is too important to simply leave it there, and I think the Court of Appeal will have to have the final say on these matters.
We've got other callers seeking clarification. Good morning. You're on the Breakfast Roundtable. Hello. Good morning.
Hello. Good morning.
Yes. Go ahead. You're on the air.
To the panel. Good morning, Mr. George.
Yes, hello.
Hello?
Yes, go ahead, please.
Yes, ma'am. I would suggest, being as the Election and Boundaries Commission override the authority by extending the 1 hour time, I should think that all benefits in the appeal would go to the person or the complainant. As a matter of clarification, it should be take into consideration that because no one will never know why the Election and Boundaries Commission override their powers. that might be never known. So I think the opposition is in a good state to appeal. Thank you.
Thanks very much, caller. Let's squeeze in another call quickly. Hello, good morning. You're on the air.
Hello, good morning to the panel.
Yes, good morning.
No, just say on the panel, I don't know if you all remembered talking about this before. I said it defies logic because it cannot affect only 5 seats. It has to affect all. And what happened to the bill? That's my first one. My second point, in listening to the leader of the opposition and in referring what the judge said to Usain Bolt and drug and whatever, to me it is looking as though she's making the judge as though she doesn't know what she's doing. That is how I look at it. And listening to her afterwards, this is not the first time when she said, we have won when they didn't win. So that is nothing really special about her. She continues to say that. But when she comes back with this property tax story, I remember the Axie tax thing that they came with, which caused plenty of people to throw the government out. She's coming back now again with, if you vote for them, the Axie tax story. So you have to look at all these things. And I think the EBC, they really have to look at what the EBC should be responsible for, because I remember too, they changed boundaries. Maybe they're responsible for doing that, but they're not responsible for extending the election time, but they could be responsible for changing boundaries. And when Dr. Munilal is talking about fraud, this is not the person who was there, who was responsible at the time, but I'm still saying they need to look at the EBC and clarify what they can or cannot do. Thank you.
Thanks very much. Martin George, your comments.
Well, I mean, the last part of what she said is, that's valid. As far as the earlier part, that goes a little bit too much into the personalization of the politics, which I always try to stay away from.
Yes, of course.
I try to stick to the legal issues, and even in the politics, when I discuss, I try to discuss principles and policies and procedures rather than getting into personality.
Okay. Let's squeeze in a call or two. Hello, good morning. You're on the air.
Yes. Mr. George, again. Mr. George, if an election, after election was held, and it was found that a rule of the election was violated, then that election becomes null and void, as far as I know, and as far as I know about elections. So that election cannot stand. So that is why I said earlier on, had they dealt only with the illegality of the elections, they would have stood a better chance. Because as far as I know, if you violate a rule of the election, that election is null and void. What do you say about that? Thank you.
Okay. Well, Jesse, Edison and Dr. Wayne, as I indicated before, there are levels or degrees of illegality. And not every illegal act would be so fundamental as to, cause the upsetting of an entire process. Even in judicial review, it sometimes happens that you may find a court ruling that, look, the action of this officer was illegal. However, it can be shown that, look, you never stood a chance in the first place. So therefore, even though, it's like if, say, for instance, you have all these cases with police officers, going for promotion challenges, etc., etc. If it can be shown that, look, the process was not correct. However, you didn't even sit the exam. So therefore, you have no marks to judge. Right? You chose to stay away and didn't sit the exam, and you have no marks to judge, or your marks were so way below that even if you went to the next person or the next batch of persons, you would never have been in that batch anyhow. Then the court would find that, yes, there was an illegality. However, it was not an illegality that you can benefit from because you never even qualified in the first place. So they don't just make blanket decisions to say, well, look, every illegality is a reason for upsetting the entire process for everything that has occurred. Otherwise, as a nation, we'd certainly be stymied, because the point is errors do occur and illegality does occur, some malicious, some benign. I think in this case, the court found that this was not anything malignant. The court found that this was benign in that it, it really didn't have any malicious intent behind it. And the court also found even if, you take it to the highest and say, well, look, this is something that is, has to be considered when you consider it against the factual matrix. All the votes that were cast after 6 p.m. could not change the result that had already occurred at 6 p.m.
Mr. George, very quickly, was introduced to the the complainant? Did they introduce into the argument? There were speculations, if you can recall, when this thing emerged, that the member of parliament, who is now the finance minister, did influence the decision or had some influence on the commissioner making that decision. Was that introduced in the argument at all, and could that stand?
From my reading of the judgment, the judge made absolutely no finding of fact that there was any influence at all. In fact, I think from the wording of her judgment, I think she was very clear that she found no finding of fact to suggest any influence in that regard.
Okay.
All right.
If there were, then that, I think, does now go to something more fundamental, because then now you are looking at not so much the issue of the extension, you're looking at the question of the independence of the EBC. And that is something then people can say, well, hey, listen, if it is that they were influenced that way or able to be influenced that way, then maybe in other areas they were influenced. So therefore, now we're going to something a little more fundamental. But the thing is, the judge made no finding of fact in that regard to say that they were influenced at all.
Thank you.
Martin George, we have to leave it there for now, but thanks for squeezing us in this morning and weighing in on this issue.
Dr. Wayne and Edison and Trinidad and Tobago, have a great morning and a great week.
Have a good day, Your Honor.
Connect with us online at sky995fm.com. Sky995.